And let's say good morning to Stan Pierchoski, Bulletproof Estate Planning.
Good morning, LB.
Good morning.
You know, every time I hear that, if we've been on the air since 1951, man, I'm tired.
Hey, I tell you.
Yeah. Well, good morning. Good morning. We are doing our show every Friday morning from 8 to 9. We call it Bulletproof Estate Planning, and while I'm thinking of it, I often forget to do this, but it is an interactive show, so we have a phone number you can call in if you want to have a question or share an experience or something. It doesn't have to be about what we're talking about today, but it should be about estate planning in general. So the number is 931-766-9393. That's 766-9393. Give us a holler, and we'll answer your question right on the air.
All right. So.
Hey, first thing I start off is what's coming up. And what's coming up is a week from tomorrow, which is November the 22nd. We're having one of our seminars. And it's at 10 o'clock in the morning. We call it Wills, Trust in the Nursing Home. And that's what we talk about. But this seminar is just a few miles north. It's going to be in Franklin. It's going to be at the Williamson County Public Library. Okay, the physical address for that is 1314 Columbia Avenue in Franklin. So if you want to come to that, it's a pretty nice drive up there, about 40 minutes or so. It's on a Saturday morning. It'll be pretty good. Weather looks like it's going to be decent. So
yeah,
there's going to be some 70 degrees tomorrow, right?
Get out of town for a little bit.
Yeah, and come listen to the seminar. If it's not too early to sign up for that. We're a week out, but we got pretty good attendance so far. As a matter of fact, what I noticed about the attendance, which was a little surprising to me, but is kind of the way things are trending, is that we have a lot of groups that were, like we get an RSVP, but they're saying they're bringing 3 to 5 people.
Mm-hmm.
So it's usually like either parents are bringing some kids or kids that are bringing parents. And sometimes it's just people that know it, kind of live in the community, and they come together. But we see a lot more of that than we used to. So we got a pretty good crowd so far. But there's room. Now, I haven't been up there yet to the Williamson County Public Library. The girls do all the scheduling of these seminars, and they checked out. They said it's pretty big and plenty of room. So it's my first time up there, so it looks interesting. We used to go to another place up there, but it's no longer available, and so they scouted around. This is the first one we're doing this year in Franklin. We usually do about 2 of them up north, just because have a lot of people request them and say, "Can you come up a little farther north?" And I get it. We're on other radio stations that reach way into Kentucky for sometimes I get people come from so many different places. It's humbling. It's just humbling. I always have to tell the story about a gentleman who drove 3.5 hours to come to my seminar.
Goodness.
And he liked it so much, he came back again with his wife and drove 3.5 hours again round trip with his wife on the next one. And then he came to a third time when he brought his wife's, or his mother-in-law, his wife's mother, because she was having some issues and stuff like that. And then we ended up doing, some work for them, both for them with some trust work and also some 10-care eligibility for the mother. So, very humbling that people would do that.
Yes.
And I once had I'll tell this story as long as I'm on it. I had a older couple, and they had decent estate, they had some farmland and stuff, and they had several kids and grandkids. They were a little bit older than me. And they were very on top of what they were trying to do. And they said they wanted to. She came up to me after the seminar and she said, "We drove 110 miles to be here, and we're going to drive 110 miles to go back home." She said, and I'm thinking, okay, I'm going to get scolded for something, right? That's what it sounds like when she starts saying it that way. But she said, we did that because we've been like 3 or 4 attorneys, and now not here locally where they were 100 miles away, and he said, no, not in one time would they let us meet the attorney. So we just wanted to see, these are older folks, they're old school. They want to meet the person they're going to deal with, kind of get a feel for them. You know how it works. I mean, you and I feel that way too. You can't just do everything in the blind. And they said, no, there's always somebody that does the intake. And she said it was cold. It was, answer the questions, not very. What's the word I'm looking for? Not very hospitable. And so they said, and even the last one they're at, she even said, "We just want to meet the attorney and talk to him for just 5 minutes. We just want to meet the person we're going to be dealing with." And it never happened. That was very frustrating to them. So they heard about my seminar that I do in person. They came and they asked a couple of questions. And then at the end of it, she said, we came here 110 miles. We're going to come back. We scheduled an appointment. We're going to drive back here 110 miles. And she says, and we may or may not go forward with the plan. We may have some more questions. I said, you ask away. Mm-hmm. And it was that connection, that human connection that made them feel comfortable. And if you're going to go to an attorney and get something done, I think you need to be comfortable with that person.
It's about like going to buy a car without test driving it.
Yeah, kinda. But you know, people now these, like I said, these are older folks, and they don't do a whole lot of internet and stuff like that. But when you have an online presence, like almost every business does these days, you can probably count on the fact that people thrash you out before they ever even come and meet you eye to eye. They look at your stuff, they look at your reviews, they look at this, and they know before they get there, they've kind of made some decision already, or actually developed some sort of trust already. So, I'm not very sure of the point I was trying to make of that, other than my seminars, I get good reviews on, but people come from all over the place. So we get a lot of Lawrence County folks when we do them over here. We do them in Giles County, we do them in Marshall, Lincoln, and Franklin County, and that's quite a few. But we spread it out throughout the year. But I get requests to do them other places too. So, and we actually went to every other month. Excuse me. We went to every other month not too long ago. So we do them a little less often because we stay pretty busy, and it's a big deal to get ready for one of those and pack everything up and go somewhere. And whatever. So anyway. I'll bring that up again at the end of the hour at the public library in Franklin. I know Jeff couldn't be here today, and you are filling in or got stuck with, or however you want to terminate phrase it.
A little bit of
appreciate it. I appreciate it. It's always good to shake it up a little bit.
If it'd been somebody besides you, I would have told them no.
That's because I can do all the talking, and you can work on something else if you have to. But. No,
saying that, I want to say that talking about the people coming everywhere and the reviews, checking that, they know what you're talking about. They know that you know your stuff, and that's what you want when you're dealing with estate planning.
That's right, and kind of other topics too. But let me tell you a story about what somebody told me. Now, this is what we call hearsay because I didn't hear it or I didn't see it, but somebody was telling me about it.
That's not admissible.
But that's right. But there was no reason why they would be telling me anything different than what it was because of the way they told it. Mm-hmm. And these are some folks that came to me, and they said, we were talking about what we're doing. I have a whiteboard in my office, and we go over the way the trust works. The trust that they were interested in, we put a lot of stuff on the board to get a little more in the weeds than we do at the seminar. At the seminar, we kind of superficially hit the high spots. Because we only got an hour, right? So, but if when we get in my office, we do a little more of a deep dive. And we got through all this, and the folks said, they kind of looked at each other and said, I think we want to go with that. And one of them said something like, yeah, I think we're going to go with him rather than the other lawyer. And I looked at them, I just kind of chuckled a little bit. And they said, and I didn't ask, because I don't say, who is the other lawyer? They just said, well, I want to tell you something. We went to a couple different lawyers. We went to one, and we were asked about 3 or 4 questions, and he sat there in front of us and Googled the answers. And when they told me that story, I thought, well, that's not going over too big. No. First of all, I can't find it hard to believe that somebody actually do that in your presence. Mm. But they asked me a ton of questions, and I think it's very. I don't pat myself in the back, but I don't think you could ask me a question about trust that I wouldn't know the answer to. If you do, I would freely admit that, boy, that's a new one, and I'd go find the answer to it, because now I'd be curious. Sure. But I do them a lot. I do them often. I've been doing them for a while. I've had so many different life experiences from people that I have to deal with and trust, and so I like to say I've seen it all, but as soon as you say that, you haven't, and something else comes down the pike. But it takes quite a bit to stump me at this point. So. But and that's the beauty of doing trust plans for people. You can solve problems that we can't solve any other way, the inheritance problems. So, actually, I'm learning a lot about. I've got some clients that are selling and buying some property, and I always knew you could do something called a 1031 exchange. Okay, I actually did one myself some years ago when I bought the building I'm in now, and so I kind of had working knowledge of it. But I ran across the concept of let me back up. 1031 exchange is when you sell a building and you want to avoid the capital gains tax. Well, you're not avoiding it, you're just kicking the can down the road is what you're doing, you're deferring it. And so, but you can do that if you take that money and roll it into a building of equal or greater value. Okay, and you have to do it within 6 months. You sell this building, you got to do it within 180 days. Okay, and if you do that, the capital gains tax is deferred. And eventually it gets paid, but you can defer it. And most people do that if they get the opportunity to. Now, I didn't, and I did that once before, and I hardly remember when, it was like, I don't know, 6 or 8 years ago, and it's hard to remember exactly what went on, but I know there wasn't much that went on with it. You have to hire a 31 exchange organization, and what they do is, like, let's say I'm buying your building, okay, and it'll say it's a nice, even $100,000. I have to give the $100,000 to the qualified intermediary, the group that's the 1031 people, then they give it to you. Then you sign the title over and you give it to them, and then they turn around and give the title to me. And that's how the IRS rules say it has to work. You and I, the buyer and seller on a 1031 can't work directly together. But I found out there's something called and that's when you set, and the property you're selling is called the relinquished property, and the property you're buying is called the replacement property. I know I could come up with better names, but that's what it is. The one you're giving up and the one you're buying, right? Mm-hmm. And so that was what we call forward 1031. But you can do, because you sell first, buy it later, okay? And so you only own one building at any given time, right? So I found out there's something called a reverse 1031. And reverse 1031 is the exact opposite. Let's just say I got a building, I'm trying to sell it, and you got the building, and all of a sudden the building, you come up and say, hey, I got this building, and I look at it and I say, man, that's great, I want it. And you say, well, I'm interested in selling it now. You know, do you want to buy or not? And I'm thinking, gee, I really want to sell my other building first so I can do the 1031, but there's a reverse one where you can buy the replacement property first and then sell the relinquished one within 180 days. It's a little more involved. And you know, I was reading the IRS rules on that, because that's what governs all that, mm-hmm. Because you're deferring a tax, so they're the ones that control it. But it was interesting, because if we want to understand how it works, think of it this way: if I own a building and I want to buy yours, then I have to buy yours first. I cannot hold title to both buildings at any given time. So if I buy yours, I own them both, right? And that's going to disqualify me from a 1031. So I got to hire this intermediator, and what they do is you know, I give the money to them, and they give the money to you. But when you give the deed to them, you don't deed it to me. They create an entity, like it's like an LLC type thing, and they create an entity, and they hold the title. They sometimes say park the title there. They're the title holder, and they will hold that title for as long as 180 days while I'm trying to sell the other one. When I sell the other one, I go through them, and then they'll deed the deed to me of the one that I bought from you. So I'll never own both buildings at the same time. And that's kind of a way to think about how that works. A little more expensive to do it the reverse way, because there's a little more paperwork involved, but you know, you can do it either direction. And you know, when you think about it, that makes sense. I mean, mm-hmm. not, you know, when if you're going to do it in this order, it's got to come up almost as much doing it the opposite way. You know, because the situation I'm dealing with, you know, the property that came up for sale was like too good of a deal to pass up, so the person wanted to go forward with it. And he couldn't wait to sell the building. Because, you know, if you want to sell a building, it's like, it doesn't happen overnight. Not like it was in 2022 when, you know, you thought about selling your building, and all of a sudden somebody's knocking at your door offering you more than you wanted. Yeah. But then again, these buildings I'm talking about were not houses, they were commercial properties. But interesting, you know, that's something I didn't know. I mean, I knew it was out there, but didn't understand it very well. Now I feel like I got a good handle on it, because I'm pretty involved in that process. So, anyway, that would be something Jeff would find interesting. He lives in the real estate world and probably sees that all the time.
He lives, breathes, and eats real estate.
He does. Well, you know, that's his business, and that's what you need to do.
That's right.
But I want to talk about something that I talked about on another show, and I want to talk about it because it connects two vital points of the stuff, what we do, and kind of drives the point home. And it's kind of hard to do on radio, but I'll do the best I can. You know, it's just, if I have a whiteboard, sometimes that helps. But mm-hmm. This is more of it's a result of a court opinion that came out. And it came out 2 years ago, June of 2023. I think I may have spoken of it before, but I'm going to talk about it again because it's been a while, and the situation came into my office in the last couple of weeks that prompted me to think about this. Because two things. One, I had somebody come into my office, they were power of attorney over somebody. And you know, you've heard me talk from time to time about a power of attorney and how to, you know, what a power of attorney is, and he puts you in a position to to act for somebody else. And, you know, it's a fiduciary duty. So when you act for somebody else, you don't just do whatever the heck you want. You're always in the best interest of the person you're dealing with, right? Mm-hmm. And that person's the principal and you're the agent, right? So they came in and they sort of had that attitude. They wanted to do something. And they said, you know, I'm not POA, I can do anything I want, right? And I said, no, it doesn't work. You can't do anything you want. And I explained the fiduciary duty and said, you know, you can't just take the person's money and go on a Hawaiian vacation, a good way to explain a fiduciary duty is like this. You get to stand in the principal's shoes, do what the principal would do if the principal could do it. Mm-hmm. And if the principal wouldn't pay for a Hawaiian vacation for you, then you can't do that. But more than that, when you act as a fiduciary and power of attorney, you really can only do what that document says you can do. Now, here's the rub. I have reviewed POAs from other attorneys until I'm blue in the face. And many of them, I'm not going to call anybody out, many of them are very brief and very inartfully drawn, in my opinion. It's an important document. It's governed by statute. We have our General Durable Power of Attorney Act, and it's governed by statute. And a lot of times they'll say words like this. They'll say, my agent can do anything and everything I can do. Now that sounds like sounds pretty all-inclusive, doesn't it? Mm-hmm. Well, it's not. And here's why it's not. There'll also be some language in these short power of attorneys that say, I incorporate all the powers under the code by reference. Because if you go to the code, there's a listing of the powers, because it's a definable thing. Well, that doesn't bring them all in. We have two kind of powers under our durable power of attorney. We have standard powers and we have enhanced powers. I call the second group superpowers because they're different. So when you say I incorporate all the powers by reference, the standard ones come over. That's right, they all do. Buy, sell, sue, be sued, stuff like that. Write checks, a lot of financial stuff. But then there's the list of enhanced powers, which are non-delegable rights. In other words, you can delegate them away, but to do so, that right has to be expressed in the four corners of that instrument. You have to, one of them is like the ability to create a trust for somebody. One of the standard powers is if you already have a trust, your POA can fund it and put property into it, okay? But there's no standard power that says you can actually make a trust for somebody. Now, there's an enhanced power that says you can establish a trust for somebody, revocable or irrevocable or whatever. But that's an enhanced power. So if that power isn't in that document, you're not giving it to that person. Mm-hmm. So when you say anything and everything, don't get fooled by that. It's not anything and everything. I think it's kind of a sloppy way for people to write power of attorney because, well, let me put it this way. Maybe a lot of folks, it'd be enough. But in my business, when I'm dealing with trusts and stuff, it's not enough. Because when you're dealing with trust, you want to put these people, have all the power they need to deal with you and or your trust. Because now the trust has a big part of your finances when you do a trust plan. And so that's what this court case was about. And so it came out of our appellate court here in Tennessee. So it's a Tennessee brand case, and so it talked about our laws. And I'll cut to the facts real quick. I found it fascinating reading because there were some other questions they answered, but the two that really hit home with me had to do with just what I'm talking about. Anyway, this case, I'll give you the facts. There was a husband and wife, and they created a living trust. Okay, and the living trust, and then they had this, and they had it for some years, and then the husband passed away. And so the wife was still around, but she was starting to decline in mental health. And so they had some children. There's only two of that I'll speak of, but one of the children, the son, he was given the power of attorney over his mom. And they owned a rental business. So they had an estate and had income producing property and stuff like that. And so they talked to an attorney about what's the best thing to do, and he said, well, the best thing to do is create this asset protection trust. You hear me talk about that all the time. I talk about it in my seminar. You sat at one of my seminars one time, and I deal about this asset protection trust where you can put property into it, and if you have creditors in the future, they can't get at this property. And of course, the creditor most people worry about is long-term care. Mm-hmm. And this case talked about that. They said, best thing to do is put this property of hers into this trust. Make her like the income beneficiary, so she has money to live off of. But we want to protect the principal. And so their attorney recommended that, and that's what the guy did. He went and created the trust, because it didn't exist before. They had a living trust, but they didn't have an asset protection trust. The living trust is a revocable trust. The asset trust is an irrevocable trust. Now, don't get hung up on those words, but the point is they're two separate trusts. They're standalone. You can't have a revocable and an irrevocable trust within the same interest. So he created it, and then he funded it with his property. He put it in. And anyway, his sister balked at that, and she said, I think the property should be distributed among all the children. We get our share. Okay. This was at Mom's death. Okay, Mom passed away then, and it was in this thing, and they wanted the business to continue. but as an inheritable asset. But she said, no, I think we ought to just cash it all out, and I just want the money to come into me. So I went to court, and the argument was that he did not have the power to create a trust for her, okay? And so she complained about it. And now, what the court did is the court pretty much said, well, whether he had the power to do it or not resides in that document. And they said, so here's what we're going to do. We're going to pull out the power of attorney document. We're going to see if he has the power. And so I'm trying to compare this with the guy that walked into my office and said, I'm power of attorney, I can do whatever I want, right? And it's okay. And I said, no, you can only do what that document says you can do, no more, no less. So the court says, we'll see if he has the power to do it. They went through some clauses in there, and they came across one of these enhanced powers, so whoever wrote that power of attorney knew what they were doing, in my opinion, and it was the ability to establish and fund trusts. And it says the POA had the ability to create a trust, not fund one that already existed, create one and fund it for the principal. And so the court said, so yeah, there's no problem with that. He's okay to make the trust. Now, but the court went even further. They really dig into stuff when you take it to them. And they said, however, in this POA, there's some language that any action that the fiduciary does, the agent, is always couched in good faith. Okay, that's what I call the best interest of. So, like I said, you can do any of these powers, but anytime you do one of these powers, it has to be in the best interest of the principal. You can't just do it because you want to do it. And so they made a big deal of that, and they should have. And they said, so let's say, okay, so we've solved the problem, so it's okay for him to create the trust. Now let's see if that trust he created, which is the asset protection trust, which I do a lot of, right? Mm-hmm. So far for me, I'm thinking, hey, this is looking great, because my power of attorneys are pages and pages long, and we list all the powers from the code, all the enhanced powers, and I take the position it's better to have a power and not need it than to need one and go to court to get it or not get it at all, because I've seen it not possible to not even get them anymore. So far I'm thinking, great, my power of attorneys are right down the alley that the court says it needs to be. I know that language is in mind, okay? So they say, okay, he has the power to do it because it says so in the power of attorney, he can create it. So she granted him that power, no problem him making the trust. Now let's look at, was making the trust in her best interest, okay? This is the asset protection trust like we do. And they go on, they say, there's evidence in the record that they went and spoke to their attorney, and the attorney testified at the trial saying, yeah, this is what we want to do. I advise to do this because if we put the property in this trust, it protects it from Medicaid recovery, okay, which is the 10-Care Estate Recovery Act. Mm-hmm. And he says, she was already in a memory care unit and stuff like that. And he said, plus it would develop a stream of income for her to help pay for her care to some extent. And it would protect that property from making her ineligible, or if she does go into long-term care, it protects that property from this estate recovery where they get paid back after death, right? So everything was right down my alley. And of course, they go through this long-winded analysis like the court does. But at the end of it, they said, by any stretch of the imagination, what making an asset protection trust for his mother was definitely in her best interest. Okay, so, I mentioned that the person came in with the power of attorney, and I said, listen, you can only do what it says you can do. I often have people say, I never heard of such thing as an asset protection trust. Is it okay to do that? I mean, do they let us do it? Does the IRS let you do it? Is it okay with the law? And I get the question, but I'm going to tell you right now, I'm pretty proud of my law license. I'm not going to throw it away by doing stuff we can't do, right? And this hit that nail right. Not only it says you can do it, it's in your best interest if somebody does it. Now, I'm talking about somebody doing it for somebody else. But the court also said because they were looking to see if first the mother could do it. If the mother could do it, then the son could do it under the trust. And it said if the mother made the trust for herself, it's definitely in her best interest to shield her property from long-term care. I mean, those words were in the trust. I mean, in the court decision. So, the answer is, these things are not. Can we do them? It's okay to do them. We have an appellate court from Tennessee saying it's definitely in your best interest to do it. And then, of course, they went a little step farther where they said, so if the principal's doing it for you, it's certain that satisfies what they were trying to solve with him, that he was acting in her best interest, because if she could do it and it's her own best interest, then her agent could do something for her that was also in, you know what I mean? Mm-hmm. Kind of that's how they put it together. Yeah. And they do it in pages and pages, but they get there. But so, that really solves two problems that people ask me about, these power of attorneys, exactly how are they used and what needs to be in them. And Second of all, they come to my seminar and say, this asset protection trust looks like a great tool, but I've never heard of such a thing. So I'm a little bit more leery, as to whether or not it's something I should do. I mean, it's hard to not talk about that without sound like a law school lecture because we're dealing with case law. But it exists. It's there. If you want to read the case, give me a call. I'll give you the citation. You can look it up. You can read it. Not too long, 18, 20 pages. But it talks about a couple other issues too. But those are ones that really caught my attention. So yeah, I mean, so what we do is sanctioned. I mean, as far as I'm concerned, that's the court's putting their stamp of approval on it, and they actually applied for the loser, the daughter, actually applied for the Supreme Court to look at it, which would be the next step up. And when the Supreme Court doesn't have to look at it. The appellate courts do. Mm-hmm. But the Supreme Court does it they can decide if they want to hear the case or not. So when they say they don't want to hear a case, that pretty much means we're satisfied the issue's settled and we're satisfied the court below did what they were supposed to do. Yeah. They'll hear it if there's a new question that's never been asked before, or if there's inconsistency, like you got the appellate court out of Jackson is different than the one out of Nashville, different than the one out of Knoxville, and to create unity, they'll hear it. Well, they applied for it's called a writ of certiorari, whether they'll agree to hear it or not. Well, they turned down the writ, and when they do so, they don't explain why. They just say we're not going to hear this case, and that's what it means. Yeah. So I'm comfortable that we got. I mean, and that's like icing on the cake because we have that behind us, and I've used that a couple times in some of the 10-care analysis that we've done, where we get into a hearing and we're arguing about something, and if it's arguing about one of these trusts, I've brought that up and said, look, these are very viable planning instruments to avoid long-term care. And it's not me saying it. Those aren't my words, Judge. That's the words of the Tennessee Appellate Court. Here, want to read it? I got it right here. I'm not that smart. I can't make that stuff up. I want to do what the courts say is okay to do, and I don't want to do the things they say is not okay to do. So that always, it's hard to just explain that to somebody when they walk in. But I just wanted to tie that together. I think that gives you a feel that what we're doing is sanctioned by the law. It's within the bounds of the law. It's available to us under the law. Why not use it? It's a very powerful tool, and it does exactly what it says it does. You put your house or your real estate in, you can put anything into it, but most people put their real estate into it, which is a big ticket item, hundreds of thousands of dollars typically, mm-hmm. and they're all over the place as far as value. You put that in, and then long-term care can never get at it. But they actually can't get at it the minute you put it in there. And then if it's been in there for 5 years, they can't calculate a penalty period for putting it in the trust. And because it's a creditor protection trust, 10-care State Recovery, who is a creditor, can't get in the trust because mm-hmm. it's a creditor protection trust. And it works like a champ. It works exactly like that. Mm-hmm. And it's a powerful, powerful tool, and it's available to us. That's why I have my seminars. I'm trying to let people know there's more options out there than what you think. Because most people go online and you can read even on other attorneys' websites, they say, if you have to go to long-term care, you're just going to lose everything. You just have to use it all to spend for your care. When it's all gone, then you can apply for 10-care. And that is not the way it happens. They say it's called spend down. They say you have to spend everything down. And what notion does that conjure up when I say that?
Well, you got to sell everything.
Get rid of it, right? Get rid of it. But not by giving it away. You got to spend it away. It surprises people when I tell them spend down is a term, but it's a legal term. It's not the one you're applying street vernacular definition to, right? It doesn't mean go on a spending spree and just sell stuff and spend it. It's a legal term. It talks about recategorizing your property. And there's nowhere, I'll throw this challenge out there if somebody wants to look, there's nowhere in the law, the 10-care Act, that says you have to spend the spend down on the cost of care. It's not there. Mm-hmm. I mean, you can look, but I have, and it's not. So there's other things you can do, and thus this trust, thus some of the stuff we do at the last minute, like these Medicare compliant annuities that we can take a countable asset and turn it into a non-countable asset, or even turn it into a non-countable stream of income. There's quite a few options we can do when people are worried. There's the people that are worried about it happening someday, but they're okay right now, everything's fine, they're just worried that it might happen someday. Mm-hmm. And there's the people where it's already happening now. We call it pre-planning and crisis. But there's options. There's other options. There's not just you're just not SOL and old poor Aunt Gertrude's just going to lose everything. That happens a lot, but it doesn't have to happen. I had recently had a group of people in for signing a trust, and they told me that I can't remember the relationship, son-in-law, something like that, was dealing with his father. And she said, he's bleeding to death financially. It's in this facility, it's $8,000–9,000 a month, and he's just beside himself because there's an end in sight. You know how much money they got in the bank, and they just don't know what to do. And I said, well, have him call me, and I'll give him what some options are. And he did, and we're actually working together. We're doing something. So, like I said, I'm on this show talking about stuff. I'm on a couple other ones. I do my seminars. I try to get the word out there, but sometimes hardly putting a dent in it, I think, because I don't know what else to do to let people know that they have these options. But a lot of people listen to this radio station, and some of the other ones I'm on, and when the marketing we use for our seminars is pretty good. It reaches out quite far. So if you haven't been to one of these seminars, you really ought to give it a shot and come see it. I get a lot of great reviews, and it's really good information. It's information packed, so don't expect it to be slow or low key. It's not. The girls call it a fire hose of information. They say, man, it's just a lot, and it is, but it kind of needs to be. So when you come to that, don't let that scare you. Just sit back and hear it. It'll sink in. The biggest problem with it is you never heard it before. When you hear something for the first time, it not all sinks in. It's like the first time. Second time around, though, it kind of starts to take hold. And it's not rocket science. It's just a thought process that you've not gone through before. But it is something that exists. So I often tell people, don't have that mindset like you get from some elderly folks.
Yeah.
Well, I never heard of that, so it can't be.
Can't be so. Well, we got a caller coming in here, Stan.
Okay, well, good.
Good morning, WDXE. You're on the air with us. I'm on the wrong station.
Mr. Pierchoski?
Yes.
Okay, I'm a little bit hoarse for allergies. I have a couple of comments and questions. I called last week and said something about putting an insurance policy in a trust, and you said you'd never done it. Well, I found that confusing, but then I'm going to clarify, do I understand it now? It's because there is a trust it doesn't have anything to do with the trust, but it has to do with it's not an asset until you die, and it becomes an asset as far as a trust or a will. I could be wrong about that. The second thing is I was in a store the other day and overheard a conversation, dying to join in. But this was the comment. Well, right now it's up in the air. He contested, but found out there was something that it could not be contested, and I knew that you could not contest a will. Is it important to be sure and put that in the trust also? And I'll hang up to listen.
Okay, thank you.
All right, the life insurance policy was issue number 1. The no contest clause was number 2. Now, let me talk about the no contest clause. Because what you said is true, but it's exactly opposite. Okay? There is something called an interim clause. It's Latin for no contest. And what it says, you can put it into a trust, and you can put it into a will if you want, but there's a difference. If you put in a no contest clause, basically what it says is if you challenge what you're going to get. So let's say you got a will or a trust that says you get 25% of my assets. And that happens, and you take the court and say, you know what, I was a better friend to this guy, and I took care of him, and I did this, and every time he needed a tool, I let him borrow it, and I think I deserve more than my 25%, okay? That is challenging what you get. And the no contest clause says if you do that, you take as if you predeceased, which really means you get nothing. Now, if you put that in a will, the probate court is required to entertain all challenges. It's not enforceable in a will. Because if you challenge a will, the probate court says, if you have to challenge it. It's still a matter of proof. You got to prove what you're complaining about. But they take on the challenge. Now, in a trust, the legislature has put the no term clause is 100% enforceable because what they base that on is the language that the legislature uses. Says the trustor, that's the maker of the trust. The trustor's intent is paramount, and absent some compelling evidence will not disturb it. So it's the opposite of what you said. You can put them in both documents, but it's extremely strong in a trust, and it's not very strong at all in a will. Now, people still put them in wills because it's kind of a deterrent. People see that and think, well, I don't want, but it's very enforceable in in a trust. Now, sometimes people will challenge things in a trust because remember I said if you challenge what you're going to get, it's no contest clause applies. But if you challenge something like the trustee or somebody or the executor of the will not doing their fiduciary duty, that doesn't trigger it. So let's say I'm supposed to get my 25%, right? And I'm not arguing that I need 35 or anything like that. Just that the trustee or the executor of the will says, you know what, I think you're a dirtbag and I don't think you should get your 25%. They shouldn't have left you anything. Okay, now he's breaching his fiduciary duty, not doing, because once a person passes away, these instruments are cast in concrete. I mean, the fiduciary of whatever it is cannot substitute their judgment for the deceased, right? They have to do what it says. And so now I can file a lawsuit against him saying he's not giving me what I'm supposed to get. I'm not complaining about what I'm getting. I'm complaining he's not giving it to me. And that you can challenge that all day long. That's a different challenge. I'm not complaining about my share. I'm complaining about not getting what the deceased wanted me to have, or something's been modified. So the no contest clause, yeah, we put them in all our trusts. And sometimes people, you know, if they insist on putting it in the will, then I'll put it in there. But I tell them up front, it doesn't mean that the court's going to say, okay, you filed a petition to challenge us. Your petition's dismissed and you don't get anything. It doesn't work that way in probate. But you know, it kind of works a lot that way in trust law. So in trust administration. So the first one was insurance policies. Let's talk about insurance policies. Let's talk about the fundamentals of one. And I'll talk about term life, easiest one to understand. Let's say you have a term life policy for $500,000. Let's make it $1 million, okay? Sounds great, right? You own nothing in that policy. You don't own a penny of it. It does, and what you said, if you have an asset, it's not an asset during life. Well, it's not an asset during life because you don't own anything. And it's not an asset at your death either, because that $1 million is the death benefit, and it doesn't go to you. And you have, as a matter of fact, not only does it not go to you, and you have no ownership in the $1 million, you have to die before it goes to somebody else. So you never have ownership in a life or term life insurance policy. There's nothing there for you to own. Now, there's a way, I'm not going to get into it, there's a way that death, or you can insure, you have a life insurance on yourself through somebody else, and then you get the death benefit. That's different. Then you're getting the death benefit, and then that is an asset. But I'm talking about most people that go out and get a life insurance policy on their own life, you know, and you do that, you know, so if something happens to you, your wife and kids taken care of, and the house can get paid off, and you know, just the prudent stuff for why you do it. Now, so you can't put it into a trust. You can only put in a trust what you own. You don't own anything there. But sometimes we can make the trust the beneficiary. Okay, but now it doesn't help us because we're gone, right? But you can make the trust the beneficiary. Now there are a set of trusts you can do. They call them ILIT. I-L-I-T stands for Irrevocable Life Insurance Trust. I don't do any of those. I'm not a fan of them. And that does talk about dealing with. It's a life insurance, a special kind of insurance policy in a trust. Okay. So I'm out of my lane talking about it. Some years ago I looked into it. I can see it's one of those things where it's very limited application. In some people's instances it might be a good thing, but for, I'd say 99% of the people I talk to, it's not. And so I don't do them because they're so rare for me to do. So I'm out of my lane talking about it. So maybe there's, you know, the answer to your question is better, somebody explaining to you how you do the ILIT, the Irrevocable Life Insurance Trust. But as far as the life insurance, now that was term. You can have whole life, or sometimes they call it universal life. But whole life is where you gain ownership, you gain equity in it. It's much more expensive than term. Term is really cheap, and if you're young and healthy, it's really cheap. As you get older and less healthy, it goes more costly. And it ends at a period. You know, they end at 72 or 80. The term ends at some point in time, and if you live longer than the term, then all those premiums were just money down a hole, right? Because it ends. And most of those, when you start approaching the end of the term, somebody will contact you and say, you can convert some of this into whole. You know, but whole life is something where you put into it, you have some ownership, it's quite a bit more expensive, but you have, at any given time, you have what's called a cash surrender value. So, and usually it's a fraction of the face of the death benefit, right? You can have a $200,000 death benefit, and after years of owning the thing, you may have anywhere from $5,000 to $20,000 cash surrender value. Now that is an asset to you. And it's an asset to you so much so that if you go into long-term care, they will expect you to cash that policy out for the cash surrender value to pay for your care. which is not something you really want to do, because the whole reason you have the policy is if you pass away, this big death benefit goes to your loved ones to take care of them, right? So that's a little different. You know, there is some ownership in that. So it's not much, usually not much, or at least not compared to that. And it depends on how long you had it, how long you've been paying on it. It gets more over time, right? So, life and even when we do that, we don't put that cash surrender value into the trust, because in order to do that, you got to crap out the whole policy. You got to surrender it and terminate it, take the cash value, and then you can put the money in the trust. Well, what we do is, what we'll do is do something with that, and try to keep the policy so it pays to our heirs. You know, we can shield that cash surrender value if we need to.
Yeah.
So, hopefully that answered the question. I know it answered the second question. The first one, not so much. I could research it, although I don't really have time to research something I don't typically normally do. I did research it at one time to the point where I decided I wasn't a fan of it. You know, I don't know that I'd recommend it, but in very limited circumstances. Because there's something we can do called domestic asset protection trust, and I am very familiar with those. But the call for those, or the good fit for those, is very rare. Comes up every now and then, but and I can do those, but you know, it's not 1 in 100 or maybe 1 in 200 trusts that we do have to do something like that. So there's quite a few different kind of trusts out there. I hone in on the ones that people, the average people that got the average kind of assets. And I don't say average as a negative thing either. I'm just saying, you know, in the mass of people, most people have a house or some kind of real estate, maybe some farmland or something. And, you know, they got a fair amount of money put into that. They may have some secondary property like vacation property or something like that. They have money in the bank, maybe some stocks, you know, stuff like that. The pretty routine assets that most people have. Domestic asset protection trusts are designed to, you know, used to have they're the fix for the foreign asset protection trust. The foreign asset protection trust is something that has to go to a foreign jurisdiction. Well, back in the late 90s, some of the states decided to create a trust where instead of sending it down to the Cook Islands or Nevis or Belize, where you can do that, you can do it here. And now that's starting to get a little bit out of the norm of what most people do. So. But you know,
it kind of sounds like shady dealings.
It does sound like it. I mean, it's not, but it is. It used to be the only thing that was available, but it's not so much shady, but there's a lot of risk because you're putting all this property. And, you know, people that do that, it's expensive property, and you're putting it in the hands of a foreign jurisdiction. Now, that's usually how those foreign jurisdictions make all their revenue for that little country. They do stuff like that, but. And they work, but there's a lot of hoops to jump through. Then at death, you know, you got to pull that back for distribution, and you know if there's anything that hadn't been done right when it comes back to this country for distribution, they can be there waiting in line. You know, it just depends if you do it right. So they're kind of dot your I and cross your T kind of trust for the most part. So we do them, but we just don't get much of a call.
Yeah.
Well, what we see mostly, people want to make sure the property gets to their heirs the way they want it to, maybe with some terms and conditions, or we talk about the asset protection trust, they want to make sure property gets to their kids and doesn't get consumed during their lifetime by something like a creditor like long-term care. And what's worth saying, I hear this all the time. People, I'll start talking about creditors, and they'll say, well, I don't have any creditors. You know, my house is paid off, my car is paid off, I don't owe anybody a dime. And that's great. You know, if you got the Dave Ramsey approach and you're out of debt, I salute you, that's great. But that's not what I'm talking about. Even if you had a home and a mortgage, or in Tennessee it's called a deed of trust, right? You're paying off the note. They're not a creditor, right? And they're not a creditor. It's like, well, yeah, they are, because I owe them, I still owe them $100,000 on my house. You know, I still got 15 years to go in the 30-year thing. They're not a creditor. And the reason they're not a creditor, the creditor is a legal term, right? They're not a creditor because you have an agreement, you have a contract, and it says my specific performances, I'm going to pay this much money every month, and their specific performances they did up front, they loaned me the money, and they're going to hold a lien on my title until it's all paid off. So as long as I'm performing the specific performance that I'm supposed to do in the contract, and they are, everything moves along, nobody's in default, right? I mean, we're doing what we said we're going to do. They're not a creditor. They've agreed to accept their money over time. So they can't say, well, you still owe us. Well, I don't owe you anything until the first of next month, because that's what the agreement is, that's the contract. They become a creditor if you default on your loan, they go to court and sue you and get a judgment for the balance or whatever. Okay? Then now they're a creditor, now they can collect. That's the creditor I'm talking about. And that's what long-term care will turn into. And another thing is you can only defeat future creditors. If you have a creditor, I've had people call me about this and say, I've got this judgment against me for $150,000, can I do that asset protection trust and protect it? It's like, nah, well, no, you can't, because that's an unfair tort on the other party. They've already got a judgment. So you can't defeat an existing creditor like that, but you can defeat future creditors. That's what the whole asset protection trust is about. Because when you put it into this trust, there's certain things that you have to give up. And what you're giving up is the access to the principal. And I talk about that quite a bit. So when you hear that, don't just say, well, if I can't get access to principal, what good is it? I don't want to do it. Well, it's better than that. But that's kind of what we're doing, because if we don't have access to principal, neither do our creditors. And so it's not ours to give them. And so, but you still maintain control over this property. And it's kind of like the concept of owning nothing but controlling everything. And that's a pretty neat concept to have when you understand how it works. You might not want to own a bunch of stuff, but if you can control it, then you've got the best of all worlds. So that's kind of what it is. There's a whole lot more to it than we get into with only 6 minutes left. So, but so again, when you hear me talk about creditors, don't think of it in terms of people that I owe money to. I mean, they're not a creditor until you don't pay them and they get a judgment. That's the kind of creditor we're talking about. Because during the contract, it's just the terms and conditions of the contract doing what the contract does over the period in time that the contract is designed to work. And a 30-year note, it's a 30-year contract.
Yeah.
All you got to do is do what you're supposed to do, and it'll never be a problem, which is pay.
Yeah.
That's not always the way it works out, but yeah. So anyway, well, we are coming down the home stretch here. Welcome to the fastest hour of my week. I don't know, we get talking about stuff, people call, and it's just, time flies by. I swear to gosh, I just looked at the clock behind you, and it was like 9:30, and I thought, how'd I get to 9:55 or something? We are. Anyway, so while we're at the end
The older you get, the faster
I
time
know,
goes.
it sure does, it sure does. We ought to have a calendar in years, not hours, right?
Yes.
You can see that one tick by. So let me just go over the seminar coming up. It is a week from tomorrow. That's November the 22nd, so it's next Saturday. And we do Saturday seminars. We do it at 10 o'clock in the morning. It's called Wills, Trust, and the Nursing Home. I do a little brief review of will versus trust. And I do that because the solution to long-term care is a trust. And I want to expose the audience, if they hadn't been already, kind of to what a trust is before I lead into the solution being a trust. So we compare the two. And then we talk about the asset protection trust, which is the solution to going broke in long-term care. And it's a grand solution. We're very fortunate to have it available to us. I think it's terribly underused. I do a lot of them. I'm doing my part, but there's a lot of folks that get in the wrong side of this and end up exhausting the person's estate to pay for care. It doesn't have to be that way.
Don't have to.
And it's not the rules are what say that, not me. I don't make it up. I'm not that smart. So I do what the rules say to do, and we just try to do that very well and make sure that that's followed. So anyway, that seminar is going to be at the Williamson County Public Library, just a little ways north. I get people that listen to me up north call and say, please bring it our way, and so we do. And Williamson County Public Library, if you want to use your GPS to get there, the physical address is 1314 Columbia Avenue in Franklin. And that'll bring you right there. That's how I'll get there. You better take me there, because that's not what I'm going to use, because I haven't been there yet. But the girls will be with me.
GPS is like some I've had. You may go to Minnesota before you get.
I tell you what, I tried to go to, I had to go to PPAC for something, to watch a play. I put in the parking place I wanted to go to. And I got within about 2 or 3 miles of it, and it kept telling me to go somewhere, so I erased it and reset it, and then it was told me to go someplace that was like 3 or 4 minutes away. And, and that finally took me there. But the initial set took me, but it's really good, but sometimes you got to keep tabs on it. So
I know a guy that took his family on vacation to Florida and used a GPS, and says after driving about 4 or 5 hours in the middle of a cornfield, he stopped on the side of the road and was going to throw it out, and they said, no, don't do that, don't do that.
Anyway, if you want to talk to me about anything we talk about or anything associated with estate planning, get a hold of me at Pierchoski Estate Law, Pierchoski Elder Law. My number is 931-363-7222, 931-363-7222, or go to my website. You can get there real easy by typing in estateplanstand.com, and that'll take you to the website. You can ask a question by email, sign up for the seminar, or just call us and sign up for the seminar. I'm glad, more than happy to answer your questions. I give the time freely. If you want to call me or email me. Will I be timely? Pretty much so. Will I answer you? Yes, I'll answer. Sometimes phone calls get returned, or emails get answered pretty quick. Phone calls, we schedule a return call. But I'll be glad to talk to you. It's a seminar. If you come to the seminar, bring your questions.
Yes.
I'll bring them with you and ask them. I won't leave the seminar until the last question's asked.
That's what you have them for.
Last week your
keep
clock.
people informed.
Last week your clock was almost a minute behind, so it looks like we got what, 30 seconds?
Yeah,
Okay.
about 45 seconds.
Again, we're on the Square in Pulaski, 931-363-7222. Give us a call if you want to talk to us, or go to my website, estate, and estate plan stand, ESTATE plan stand. That'll get you right there, .com. That'll take you right to it. So
And
remember, doing nothing yields a predictable result.
And don't do, as an old preacher, my grandmother and granddad used to say, an old preacher said, he got up to preach, he'd say, now don't do as I do as I say.
There you go.
Pre-plan this trust.
Yep.
If you've got the funds and you've got the means, go ahead and get it started and don't take a chance.
It's a grand tool. It's a grand tool.
It is. I mean, I've been to the seminar and it's the way to go. I hadn't done it yet, but it's the way to go. All right, well, Stan.
Okay. Always a pleasure. We do this every Friday morning from 8 to 9.
And Jeff will be back with you next week unless something comes up between now and then.
Always a pleasure, LB.
Administration canceled a Biden transportation department plan that would have required airlines to pay passengers compensation in cash, not vouchers or credits or miles, when their flights are delayed at least 3 hours. The state of this morning says that.
Okay, I gotta run to the Register of Deeds office, record a few things.
Productions are frozen at 6%, but remember, if the government shutdown didn't end, it would have been at 10% by today. So the FAA safety team is going to be monitoring the airspace.